I noticed that there are two threshold questions that are, I think, making the rounds among the senator judges. One has to do with when does a mistake or a failure to liquidate become a criminal act? No? I think that was the point of Senator Alan Peter Cayetano. And then secondly, and this is the point of the presiding officer, Chis Escudero, when does the presumption, the prima facie failure to liquidate being prima facie evidence, presumption of personal use na ginamit ng accountable officer yung pera na hindi na liquidate, when does that come in? No? Does it come in only when there's an ND or afterwards or before that? Can I have your thoughts on this, please, on these two threshold questions?
Okay, may I say something? I think this is important before we lose
yes, of course.
Regarding the conflict of interest of Attorney Poa, I think he is suffering from a conflict of interest, and he placed himself in a position where he'll be required to testify as Chief of Staff and Undersecretary for Finance of the DepEd at the time when the Vice President was its secretary. And as Undersecretary for Finance, he has intimate knowledge of how the confidential funds were used during that time. And by making himself counsel of the Vice President, I think he's representing interest that is contrary to that of the Republic, which is subject of, if I can recall, Canon 3 of the Code of Professional Responsibility and Accountability. Because if he is asked to testify on knowledge during the time that he was Undersecretary for Finance regarding the use of the confidential funds, he can simply escape and evade those answers by saying, I will not answer because it will breach attorney-client privilege. So he's now serving two masters. So that I leave that to the impeachment court to decide. So going back to your final questions, sorry, I really felt a necessity to make a comment on a serious ethical issue that most of us have overlooked just because Attorney Poa appears to be kinder than his predecessors. We're so easily impressed by someone who does not reflect the brutish character of their client, as did the first three counsels of the defense. Anyway, this is a serious ethical issue. Okay. So let me point that out as a fellow lawyer. And so going back to your questions.
Sorry, can I interrupt you there? So Senator Chis Escudero already ruled on the point of order of Senator Raffy Tulfo. Is this a conflict of interest? Sabi ni Chis, no. Is it possible that they will return to this? That maybe after hearing
yes. you? I hope they do return to that issue because, remember, Attorney Michael Poa is a common witness for both.
Yes,
and I think the prosecution is planning to present him as a hostile witness. And as a hostile witness, I can just hear now what he will answer whenever the prosecution lawyers ask him questions. I cannot answer because it will breach attorney-client privilege. So how do you reconcile that with the fact that he was handling public funds at the time when he was Undersecretary for Finance, and his fidelity at that time was towards protection of public funds and fidelity to public office, public office being a public trust. So I cannot reconcile the two roles that he placed himself in right now. So it's something that I hope the senators will keep going back to, and I hope Attorney Poa himself would reflect on, try to gain some insight about so that he can recuse himself from further participating as counsel in these proceedings.